I find it genuinely amusing, Senator Rand Paul declared, a dismissive smile playing across his face as he leaned toward the microphone. The Senate Judiciary Committee hearing room fell silent as the Kentucky Republicans' signature combative style emerged. Congresswoman Crockett argues that the founders would support federal intervention in state voting procedures, he continued, shaking his head. Anyone who's actually read the Constitution knows the framers intentionally left election administration to the states. That's fundamental federalism. The camera cut to Representative Jasmine Crockett, seated across the hearing room. Unlike other witnesses who had wilted under Paul's pointed questioning, the Texas Congresswoman remained composed, calmly reviewing notes before her. Paul continued, his voice rising with practiced indignation. Perhaps the Congresswoman from Texas could point to where exactly in the Constitution this imagined federal authority exists? Because I've studied this document extensively, and it simply isn't there. As laughter rippled through the Republican side of the dais, Paul settled back in his chair with the satisfied expression of someone who had just delivered an unanswerable challenge. Chairman Graham turned to Crockett. The Congresswoman may respond. Crockett looked directly at Senator Paul, her voice steady and deliberate. Thank you for the opportunity to clarify, Senator. I'd be happy to cite the Constitution directly. She lifted a small leather-bound book from the table. Article 1, Section 4, first paragraph. The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But, she paused meaningfully, the Congress may at any time by law make or alter such regulations. The room fell silent as she continued. And regarding the founders' intent, perhaps you'd appreciate this quote from Alexander Hamilton in Federalist 59. Nothing can be more evident than that an exclusive power in the state legislatures to regulate elections for the national government would leave the existence of the Union entirely at their mercy. Senator Paul's smile vanished. For perhaps the first time in his Senate career, the typically quick-witted libertarian physician appeared completely frozen, his prepared follow-up suddenly irrelevant. What followed wasn't just a constitutional lesson. It was a moment that would transform the national conversation about voting rights, federalism, and who truly understands the founders' vision for American democracy. Hit the subscribe button right now to see the full exchange that left a Senate committee stunned and reignited debate about the true meaning of constitutional federalism in ways that crossed traditional partisan lines. Senator Rand Paul had built his political identity on unwavering defense of what he considered constitutional originalism. The second-term Kentucky Republican and son of libertarian icon Ron Paul had established himself as one of the Senate's most vocal advocates for strict limits on federal power. An ophthalmologist before entering politics, Paul approached constitutional questions with the same certainty he had once brought to medical diagnoses. His Senate questioning style was instantly recognizable. Begin with foundational principles, identify perceived inconsistencies in opposing positions, then deliver pointed challenges designed to expose what he viewed as constitutional illiteracy. What makes Senator Paul effective is his absolute conviction, noted political analyst Robert Williams. He approaches constitutional debates not as political disagreements, but as objective questions with definitively correct answers he believes are self-evident to anyone who truly understands the founders' intent. This approach had proven particularly effective in committee hearings, where Paul regularly created viral moments by challenging witnesses he believed were promoting expansive federal authority. His questioning typically followed a recognizable pattern. Cite specific constitutional language, contrast it with the witness's position, then demand they reconcile the apparent contradiction. Paul's effectiveness comes from his precision, observed constitutional scholar James Thornberry. Unlike many politicians who speak in generalities about the Constitution, he cites specific clauses and principles, making his challenges difficult to dismiss with platitudes or talking points. In recent months, Paul had focused this formidable talent on questions of election administration as Congress considered the Voting Rights Advancement Act. The legislation proposed significant federal oversight of state voting procedures, triggering Paul's Federalist objections. The Constitution clearly leaves election administration to the states, he had argued repeatedly in media appearances. Federal micromanagement of local voting procedures represents exactly the kind of centralization the founders fought against. This position, defending state authority against federal oversight, had made Paul a leading voice among conservatives opposed to the legislation. His office had published a widely circulated white paper titled Election Integrity and Constitutional Federalism, establishing him as the Senate's most prominent constitutional critic of the bill. Representative Jasmine Crockett presented a striking contrast in both style and substance. The second-term Congresswoman from Texas had entered politics after a distinguished career as a constitutional attorney specializing in voting rights litigation. Unlike Paul's self-taught constitutional approach, Crockett brought formal legal training and courtroom experience to legislative debates. What distinguishes Representative Crockett is her historical depth, noted Harvard law professor Melissa Rodriguez. She doesn't just know constitutional language, she understands the historical context around its development and how courts have interpreted it over time. Before her election to Congress, Crockett had successfully argued several significant voting rights cases before federal appellate courts. This litigation experience had given her intimate familiarity with both the constitutional foundations of voting rights and the practical challenges of election administration. Crockett approaches constitutional questions differently than most politicians, observed legal analyst Michael Chen. Rather than treating the document as a collection of absolute principles, she sees it as a coherent framework where provisions must be interpreted in relation to each other and the broader constitutional structure. This approach, contextual rather than isolated interpretation, reflected her professional background. As a litigator, she had learned that constitutional arguments prevailed not through passionate advocacy alone, but through meticulous documentation and historical evidence. In Congress, Crockett had quickly established herself as one of the most effective defenders of the Voting Rights Advancement Act. Rather than focusing solely on policy outcomes, she had grounded her advocacy in detailed constitutional and historical analysis that even opponents found difficult to dismiss. Representative Crockett doesn't just argue that the bill would produce desirable results, noted congressional reporter Sarah Johnson. She builds methodical arguments about why the legislation represents a proper exercise of explicit constitutional authority. The collision between these two distinct constitutional perspectives, Paul's strict federalism versus Crockett's integrated approach, had been building for months. As primary sponsor of the House version of the Voting Rights Advancement Act, Crockett had been invited to testify before the Senate Judiciary Committee, where Paul served as a senior member. The stage was set for a consequential exchange between two of Congress's most articulate constitutional voices, one championing strict division between federal and state authority, the other advocating a more nuanced view of how these powers interacted in the constitutional framework. What factors do you think should determine how we interpret constitutional provisions today? Share your thoughts in the comments below about whether strict original understanding or evolving interpretation better serves democratic governance in modern America. The Senate Judiciary Committee hearing had begun with predictable partisan positioning. Democratic senators emphasized documented instances of voter suppression, while Republicans focused on state sovereignty and the potential for federal overreach. Chairman Graham had structured the hearing to alternate between supportive and critical witnesses. After testimony from two election law professors, Representative Crockett was introduced as the primary House sponsor of the legislation under consideration. Crockett's opening statement had departed from typical congressional testimony. Rather than focusing primarily on policy outcomes, she had methodically outlined the constitutional foundations of federal authority over elections. The Constitution creates a careful balance, she explained. States administer federal elections, but Congress retains explicit authority to modify those regulations when necessary to protect the integrity of national representation. This framing, grounding federal oversight in constitutional text rather than policy preferences, had visibly irritated several Republican committee members who had prepared to challenge the legislation on constitutional grounds. Their planned questioning strategy, focused on alleged constitutional overreach, required adjustment given Crockett's preemptive constitutional defense. When Senator Cruz attempted to challenge the bill as contradicting Federalist principles, Crockett responded with specific historical context that left the Texas senator uncharacteristically flustered. "Senator, the Reconstruction Amendments fundamentally altered the federal-state relationship regarding voting rights," she explained. "The 15th Amendment explicitly empowers Congress to enforce prohibition of racial discrimination in voting through appropriate legislation. The Supreme Court has repeatedly affirmed this enforcement authority." This pattern, constitutional challenges met with specific textual and historical responses, continued through several rounds of questioning. Unlike many congressional witnesses who retreated to talking points when challenged, Crockett engaged directly with each constitutional objection, providing specific citations that complicated simplistic Federalist arguments. The dynamic shifted noticeably when Senator Rand Paul began his questioning. Unlike his colleagues who had moderated their approach after witnessing Crockett's constitutional expertise, Paul leaned into his signature confrontational style. "I find it genuinely amusing," he began with evident dismissiveness, "that Congresswoman Crockett argues the founders would support federal intervention in state voting procedures. Anyone who's actually read the Constitution knows the framers intentionally left election administration to the states. That's fundamental federalism." Paul's tone, combining condescension with absolute certainty, signaled his expectation of creating one of his trademark viral moments at the witness's expense. "Perhaps the Congresswoman from Texas could point to where exactly in the Constitution this imagined federal authority exists," he continued. "Because I've studied this document extensively, and it simply isn't there." The laughter from the Republican side of the dais suggested they anticipated Crockett would struggle with this direct challenge to produce specific constitutional language supporting her position. Crockett's calm response, directly citing Article 1, Section 4's explicit provision that Congress may at any time by law make or alter such regulations regarding the times, places, and manner of holding elections, caught Paul visibly off guard. The exact constitutional language he had confidently declared simply isn't there was being read directly from the document. More devastating still was her follow-up citing Alexander Hamilton's Federalist 59, which explicitly warned against exclusive state control over federal elections. By invoking Hamilton, a founder particularly respected by conservatives, Crockett had not just countered Paul's argument, but inverted it entirely. She had demonstrated that the original understanding he claimed to defend actually supported congressional authority in precisely the way the legislation proposed. The silence following her response spoke volumes. Senator Paul, normally quick with retorts, appeared genuinely stunned. The constitutional certainty that defined his political persona had collided with specific evidence he seemed unfamiliar with, despite his claims of extensive constitutional study. After an uncomfortable pause, Paul attempted to recover. Hamilton wasn't speaking about the specific types of regulations contemplated in this legislation, he argued, his usual confidence notably diminished. Crockett was prepared for this pivot as well. "With respect, Senator, Hamilton specifically mentioned in that same paper the danger of states using their regulatory power to manipulate representation through an uncontrollable power over the very existence of the national government. The Voting Rights Advancement Act addresses precisely this concern by ensuring state regulations don't effectively disenfranchise eligible voters." This response, connecting Hamilton's specific concerns directly to the legislation's purpose, further undermined Paul's position. The senator's expression revealed growing recognition that this exchange was not following his expected script. Chairman Graham, sensing the unusual dynamic, extended Paul's questioning time. "The senator from Kentucky has 2 more minutes." Paul shifted approach, moving from constitutional text to broader philosophical arguments. "The principle of federalism requires respecting state sovereignty," he stated. "Federal micromanagement of election procedures undermines the decentralization that protects liberty." Crockett nodded respectfully before responding. "The founders certainly valued state sovereignty, Senator, but they recognize competing constitutional principles sometimes necessitate balancing that sovereignty against other concerns. She continued with growing confidence. Madison addressed this directly in Federalist 51, arguing that constitutional design requires supplying, by opposite and rival interests, the defect of better motives. The congressional authority over elections serves precisely this function, creating a counterbalance when state interests might conflict with ensuring fair national representation. This response, using Madison's own words to explain why federal checks on state election authority protected rather than undermined constitutional design, demonstrated sophisticated understanding of how Federalist principles operated within the broader constitutional framework. The exchange had moved beyond typical congressional posturing into substantive constitutional dialogue. Even senators not serving on the committee had begun filtering into the room, drawn by word of the unusually substantive debate unfolding. Paul made a final attempt to reassert his constitutional authority. The 10th Amendment clearly reserves powers not explicitly granted to the federal government to the states, he noted. The expansive oversight in this legislation goes far beyond what the founders would have recognized as legitimate federal authority. Crockett's response would become the exchange's defining moment. "Senator, I agree completely about the importance of the 10th Amendment," she began, "but its application depends entirely on whether the Constitution does explicitly grant the power in question." She held up her pocket Constitution again. Article 1, Section 4 explicitly grants Congress authority over federal elections. The 14th and 15th Amendments explicitly grant enforcement power regarding equal protection and voting rights. The Supreme Court has repeatedly confirmed these explicit grants of constitutional authority. She concluded with quiet conviction. The 10th Amendment reserves powers not delegated to the federal government. But these powers were explicitly delegated. That's not my interpretation, Senator. It's the Constitution's plain text and the founders' explicit design. This methodical dismantling of Paul's constitutional objections, using specific text, founder statements, and structural analysis, had transformed what began as an attempted gotcha moment into a masterclass in constitutional interpretation. Even senators who disagreed with the legislation appeared struck by the depth of Crockett's constitutional knowledge. As Paul's questioning time expired, the committee room remained uncharacteristically silent. The expected partisan theater had been replaced by something far more substantive, a genuine exploration of how constitutional provisions interact and how competing principles might be balanced in a democratic system. Chairman Graham, himself appearing somewhat surprised by the exchange's depth, called a 10-minute recess. As senators and staff members filed out, the buzz of conversation revealed that something remarkable had occurred. A constitutional debate of actual substance had broken through the typical congressional performance art. What had begun as Senator Paul's attempt to create a viral moment at Representative Crockett's expense had evolved into something far more significant, a public demonstration of how serious constitutional engagement might elevate American political discourse beyond simplistic invocations of founding principles. When the hearing resumed, the tone had noticeably shifted. Senator Kennedy of Louisiana, normally one of the committee's most combative questioners, began with unexpected candor. "Congresswoman Crockett, I still have serious concerns about this legislation," he acknowledged. "But I appreciate the constitutional seriousness you've brought to this discussion. Too often we talk past each other instead of engaging with substance." This acknowledgement, that constitutional disagreements could reflect good faith differences rather than ignorance or bad intent, marked a significant departure from typical committee dynamics. Other Republican senators similarly adjusted their approach, shifting from dismissive challenges to more substantive engagement with the constitutional questions at hand. Senator Paul himself remained notably silent for the remainder of the hearing, reviewing what appeared to be the Federalist Papers on his tablet. This visible reconsideration, a senator known for constitutional certainty actually consulting primary sources, perhaps best symbolized the exchange's impact. The aftermath extended far beyond the committee room. Clips of the exchange between Paul and Crockett quickly went viral, but not in the way political confrontations typically spread. Rather than celebrating a gotcha moment, Viewers across the political spectrum expressed surprise and appreciation for the substantive constitutional dialogue. "I've watched congressional hearings for decades," wrote one conservative commentator, "and can't remember the last time I saw actual constitutional analysis rather than talking points. Whether you support or oppose this bill, that exchange was what congressional testimony should be." Law professors noted the pedagogical value of the exchange, with several incorporating the clips into their constitutional law courses. In 10 minutes, this dialogue covered federalism, original understanding, and structural constitutional principles more effectively than many textbook chapters, observed Georgetown law professor James Martinez. Media coverage reflected this substantive impact. Rather than focusing solely on the political horse race aspects of the legislation, analysis expanded to include the specific constitutional provisions at issue and their historical context. The New York Times published an unusual joint op-ed featuring constitutional scholars from both progressive and conservative perspectives evaluating the exchange. While disagreeing on the legislation's merits, both authors praised the elevation of constitutional substance over soundbites. "Whatever one thinks of the Voting Rights Advancement Act," wrote conservative scholar Robert Williams, "Representative Crockett's defense demonstrates that progressive positions can be grounded in serious constitutional analysis rather than merely policy preferences. This strengthens our constitutional discourse regardless of outcome." For Senator Paul, the exchange prompted noticeable evolution in his approach to constitutional questions. In subsequent committee hearings, observers noted increased precision in his constitutional references and greater acknowledgement of competing textual provisions. 2 weeks after the hearing, Paul made a remarkable statement during a Fox News appearance. When asked about the constitutional problems with the voting rights legislation, he responded with unexpected nuance. "The constitutional questions are more complex than sometimes portrayed," Paul acknowledged. "While I still have federalism concerns, Article 1 does explicitly grant Congress certain authority over federal elections. The debate should focus on the proper scope of that authority rather than denying it exists." This statement, acknowledging constitutional complexity rather than absolute certainty, represented significant growth for a senator who had built his brand on constitutional absolutism. Several conservative commentators expressed surprise at Paul's more measured approach, though most ultimately praised it as intellectual honesty. For Crockett, the aftermath brought expanded opportunities to elevate constitutional discourse beyond partisan boundaries. Conservative legal groups that had previously dismissed her as just another progressive politician now invited her to debates and forums focused on constitutional interpretation. "Representative Crockett brings something essential to constitutional discussions," explained Federal Society Chapter President William Harrison when announcing her invitation to a constitutional symposium. "Even when we disagree with her conclusions, her rigorous textual and historical analysis demands serious engagement rather than dismissal." This cross-ideological recognition that constitutional seriousness transcended partisan alignment created space for more productive dialogue on previously gridlocked issues. Crockett leveraged this opening to build unlikely alliances on specific aspects of voting rights protection that could potentially attract bipartisan support. Perhaps most significantly, the Senate Judiciary Committee announced an unprecedented series of hearings titled Constitutional Foundations of Election Administration. Unlike typical hearings designed for partisan positioning, these sessions explicitly aimed to explore the constitutional text, history, and precedent relevant to federal and state election authority. Before debating specific legislation, we should establish a shared understanding of the constitutional framework, Chairman Graham stated. These hearings will feature constitutional scholars from diverse perspectives, helping us understand the proper balance of authority in our federal system. This approach, prioritizing constitutional understanding before policy advocacy, represented a striking departure from typical legislative process. It suggested that Crockett's constitutionally grounded advocacy had influenced not just individual lawmakers but potentially the institutional approach to politically charged issues. 6 weeks after the initial hearing, the committee released a bipartisan report titled Constitutional Parameters of Federal Election Oversight. While not endorsing any specific legislation, the report acknowledged both explicit constitutional authorization for federal election regulation and legitimate federalism considerations that should inform its scope. The Constitution creates a complex balance regarding election administration, the report stated. Article 1 explicitly grants Congress authority to make or alter state election regulations for federal offices. The Reconstruction Amendments further empower federal protection of voting rights. However, federalism principles suggest this authority should be exercised with appropriate respect for state responsibilities. This nuanced framing, acknowledging both federal authority and federalism concerns, created potential space for legislation that might bridge partisan divides. It suggested that Crockett's constitutionally serious approach had helped shift the debate from absolute positions toward principled compromise. For the legislation itself, this constitutional seriousness translated into tangible progress. Rather than dying in committee as similar bills had previously, the Voting Rights Advancement Act advanced to the Senate floor with several amendments reflecting federalism considerations raised during the hearings. This legislation still faces significant challenges, noted Senate reporter Michael Chen. But unlike previous versions, it has established legitimate constitutional foundations that make outright dismissal more difficult. That shift in framing, from pure policy preference to constitutional authority, has meaningfully changed the legislative dynamics. The most remarkable development came when Senator Paul himself proposed an amendment to the legislation. Rather than simply opposing the bill outright, he offered modifications designed to respect state authority while addressing legitimate federal concerns about voting rights protection. "I still have reservations about federal oversight," Paul acknowledged when introducing his amendment. "But Article 1 does grant Congress specific authority in this area. The question is how to exercise that authority consistent with broader constitutional principles." This approach, engaging with legislation's constitutional foundations rather than dismissing it entirely, represented exactly the kind of substantive engagement Crockett's testimony had aimed to encourage. It suggested that constitutional seriousness, convincingly presented, could potentially bridge partisan divides, even on highly charged issues. For those who had witnessed the original exchange between Paul and Crockett, this evolution was particularly striking. What began as attempted constitutional dismissal had transformed into substantive constitutional engagement. It demonstrated how serious constitutional dialogue could potentially elevate political discourse beyond partisan performance toward shared understanding of founding principles. The long-term impact of the Paul Crockett exchange extended far beyond a single piece of legislation or viral moment. What began as constitutional confrontation evolved into something with lasting significance for both legislative process and public understanding of constitutional governance. 1 year after their initial exchange, Harvard's Center for Constitutional Studies conducted a comprehensive analysis titled Constitutional Dialogue and Democratic Deliberation. The study examined how the Paul Crockett model of substantive constitutional engagement had influenced congressional proceedings across multiple committees and issue areas. Our research identified a measurable shift in how constitutional authority is discussed in congressional hearings, the study reported. References to specific constitutional provisions increased by 64% compared to the previous session, while general invocations of what the founders intended without specific citation decreased by 42%. This change, from abstract appeals to founding principles toward specific textual and historical references, suggested that the exchange had established a higher standard for constitutional discourse in congressional proceedings. Lawmakers increasingly recognized that effective constitutional advocacy required specific knowledge rather than merely rhetorical flourishes. Legal education experienced meaningful evolution as well. Law schools reported increased student interest in courses connecting constitutional theory to practical governance challenges. Several institutions developed specialized programs focused on preparing future lawmakers and policy advocates to engage seriously with constitutional foundations of legislative authority. The Paul Crockett exchange demonstrated how constitutional expertise shapes effective advocacy, noted Yale Law School Dean Sarah Williams. That visible application of constitutional knowledge to real governance questions attracts students interested in bridging theoretical understanding and practical impact. For Senator Paul himself, the experience catalyzed notable evolution in his constitutional approach. While maintaining his libertarian principles, he increasingly grounded his positions in more nuanced constitutional analysis that acknowledged textual complexities and competing foundational values. In a surprising development, Paul partnered with a progressive constitutional scholar to develop a series of lectures titled Constitutional Textualism Across the Political Spectrum. These presentations explored how serious engagement with constitutional text could lead to different policy conclusions while maintaining shared commitment to constitutional governance. Meaningful constitutional dialogue requires recognizing that reasonable people can interpret the same text differently, Paul acknowledged during one lecture. Our constitutional system depends on engaging with those differences honestly, rather than dismissing opposing interpretations as ignorant or illegitimate. This perspective, that constitutional disagreement could reflect good faith difference rather than bad intent, represented significant growth for a senator previously known for constitutional absolutism. It suggested that serious constitutional challenge, when substantively presented, could prompt intellectual development even among the most certain advocates. For Crockett, the aftermath further established her as one of Congress's most effective constitutional voices. Rather than being pigeonholed as a partisan advocate, she gained recognition across ideological boundaries for bringing substantive legal analysis to legislative debates. Most significantly, Crockett's approach influenced how other lawmakers framed their advocacy. Junior representatives from both parties studied her method of grounding policy positions in specific constitutional provisions and historical context. This approach, establishing constitutional legitimacy before policy specifics, proved increasingly effective in building broader coalitions. Representative Crockett demonstrated that constitutional seriousness enhances rather than limits effective advocacy, observed congressional scholar Robert Martinez. By establishing firm constitutional foundations for her positions, she made them more difficult to dismiss on purely partisan grounds. This insight, that constitutional depth strengthened rather than weakened political advocacy, challenged conventional wisdom about congressional communication. It suggested that substantive expertise, properly communicated, could actually enhance political effectiveness rather than diminishing it. Perhaps the most lasting institutional impact emerged in how Congress approached constitutional questions more broadly. The Senate Judiciary Committee formalized a new practice of holding dedicated constitutional foundation hearings before considering major legislation affecting federalism, separation of powers, or individual rights. Unlike typical hearings designed primarily for partisan positioning, these sessions featured constitutional scholars from diverse perspectives establishing the relevant constitutional parameters before policy specifics were debated. This approach, prioritizing constitutional understanding before policy advocacy, represented a significant procedural innovation. By establishing shared constitutional context before specific policy debates, these hearings create foundation for more productive legislative engagement, explained Committee Chairman Graham. We may still disagree about policy applications, but beginning with constitutional foundations helps ensure those disagreements reflect legitimate differences rather than constitutional misunderstanding. This process innovation, separating constitutional analysis from immediate policy advocacy, created space for more substantive engagement across partisan lines. It acknowledged that constitutional seriousness required institutional structures supporting thoughtful deliberation rather than merely individual knowledge. The media landscape demonstrated subtle but meaningful evolution as well. Political reporters increasingly distinguished between constitutional disagreements reflecting different interpretive approaches versus factual misunderstandings of constitutional provisions. This more nuanced coverage helped audiences understand that constitutional questions often involved legitimate interpretive differences rather than simple right-wrong distinctions. What the Paul Crockett exchange revealed was the possibility of substantive constitutional dialogue even in highly partisan contexts, observed political analyst Jennifer Lawrence. When participants prioritize constitutional understanding over immediate political advantage, our discourse naturally becomes more productive even amid significant disagreement. On the third anniversary of their original exchange, Paul and Crockett participated in an unprecedented joint interview exploring how constitutional dialogue could strengthen democratic governance. Though maintaining their distinct political perspectives, both emphasized how serious engagement with opposing constitutional views had deepened their own understanding. "We still reach different conclusions on many issues," Paul acknowledged, "but engaging seriously with Representative Crockett's constitutional arguments made me a more effective advocate for my own positions. Constitutional dialogue should strengthen rather than weaken our distinct perspectives." Crockett expressed similar sentiment from her progressive perspective. "Constitutional text belongs to all Americans, not any single ideology," she noted. "When we engage seriously with the document's complexities, rather than reducing it to simplistic talking points, we honor the sophisticated system the founders actually created." This shared appreciation that constitutional seriousness transcended partisan alignment offered a potential model for elevating American political discourse beyond its increasingly polarized state. It suggested that shared commitment to constitutional governance could potentially bridge partisan divides, even when policy disagreements remain significant. As constitutional scholar James Madison, no relation to the founder, observed on the 5th anniversary of the original exchange, what Paul and Crockett demonstrated was that constitutional text provides not just rules, but a shared language for democratic deliberation. By engaging seriously with specific provisions rather than abstract principles, they created possibility for dialogue across deep political difference. This legacy, establishing constitutional text as common ground for democratic deliberation, extended far beyond the specific legislation or individuals involved. It offered a potential path toward political discourse that honored both principled disagreement and shared constitutional foundations. In an era when democratic institutions face significant challenges, Madison continued, the model of constitutionally grounded dialogue demonstrated by Paul and Crockett reminds us that disagreement itself isn't the problem. The challenge is cultivating disagreement that strengthens rather than weakens our constitutional system. This perspective, that constitutional seriousness could transform political conflict from destructive to constructive, captured the essential hope emerging from their unexpected exchange. It suggested that America's constitutional tradition, when approached with genuine seriousness by voices across the political spectrum, might still provide foundation for democratic flourishing amid deep difference. If you believe in the importance of substantive constitutional dialogue that transcends partisan talking points, share this video with others who value thoughtful engagement with our founding principles. And don't forget to subscribe for more content exploring how our constitutional tradition can help navigate today's most challenging political questions. Together, we can build a political discourse worthy of the sophisticated system the founders created.